Yeah, okay. At the last hearing, Advocate Mnisi addressed the court on the basis that his client has been unlawfully detained, in the sense that he spends only 1 hour out of the 24 hours where he could say that is his own time in prison, where he's allowed, supposed to have exercises, etc. Mr. Mnisi also complained about the fact that he sometimes cannot have the opportunity to consult with his client. So the last hearing, I undertook to speak to Judge Cameron. I didn't do it.
I didn't do it, says Judge Ratha. Of course, he cites his reasonings. Not only does he cite his reasonings, he also comes up with a case to back it up. So, hello, Mzansi. Welcome back to my channel. Guess what? Court actually did go into session without a hic, but immediately we started off with the court. Okay, first of all, Baloyi reminding the court where we're at, and the court very impatient and ready to go into what he has to say, which is, I didn't do it. Okay, I did not call my brother Justice Cameron to come over. Forget about it. You are on your own. Accused number 3. I sympathize with you. I sympathize with you that you are in solitary confinement for 4 years, but you must understand that this court is unable to assist you. And then Judge Ratha goes into so many reasons why not, but pay close attention to Advocate Mnisi. That is the kind of attorney you need. That is the kind of advocate you need. That is the kind of lawyer that you need. I salute Mnisi one more time. And while we're on the topic, there was a comment I remember on my last video when I spoke about this before they went on recess, actually the Friday of recess beginning on the Monday after that. And I was saying, I am just so impressed with Judge Ratha. Thank you so much. This is great news, blah, 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 blah. Okay. I literally was blabbering. And I am a very, very optimistic person. This comment came in, and the comment said something along the lines of, I'm going to try to look for it. But the comment literally said, Judge Ratha is just, lying. He's not going to do it. Literally, the comment said exactly this. Exactly how it happened is what this comment said. And I remember my initial reaction at the time being, why are people so pessimistic? Let's give Judge Ratha a chance. I mean, he on his own, unprovoked, mentioned his BFF and that he was going to approach him and that they were out at dinner with the others and how they feel this is very unconstitutional and psychological, blah, blah, blah. This was all out of Judge Ratha's mouth. This comment, as had said, he's tricking us. Well, hello. Boy, do I feel like I have egg on my face. Wow. As he said, I did not do it, but let's go ahead and listen to the reason why he did not do it and what happens next. Let's keep going. Remember to stay till the end because there's an absolute surprise twist to all this. Oh my goodness.
Because when I told the JP Lambo that I intended approaching him in connection with your client's complaints, he told me that Cameron, judge, had already written a letter to him. In that letter, they were discussing, amongst other things, the fact that judges of the high courts, when they make orders which proclaim accused persons who are there who are detained, pending them being certified to be compos mentis, meaning that they can stand trial. But before they do that, a psychologist, psychiatrist, or doctor must examine that type of person. And normally the judges only make a blanket order that the accused person is referred to Sterkfontein or whichever hospital, mental hospital or vet copies, whatever. And sometimes in the system, the accused persons are never again visited upon by the psychiatrist. So Judge Cameron was complaining that these persons fall through the cracks because their detention is not defined. And he was insisting that maybe judges should make orders defining exactly that this 90-day period, what should happen to it. And preferably an order which is justifiable to detain this person for mental examination should be about 90 days, but within 90 days or at the end of 90 days, that person should again be seen in court by a judge who will then determine whether in fact this person is being treated or not. Judge Cameron also made mention, it's public knowledge, that he believes that some of the detentions are, as he puts it, are inhuman in the sense that they do not have consideration of the constitutional rights of some of the prisoners, and that sometimes the Bill of Rights has been compromised in that fashion, in that they are not given enough time to go and exercise, they are not accorded time to be visited by their loved ones or relatives or wives, and that he thought that exigency should be visited upon by the Department of Correctional Services, which apparently he did. And J.P. Mlambo, when I discussed that there is this complaint about the human rights pertaining actually to the detention or the confinement of awaiting trial prisoners, or there are certain complaints which have been visited upon, for instance, by Mr. Mnisi. The JP's view, which I agree with, is that this is a comprehensive question of the alleged infringement of the Bill of Rights, and he cannot alone, because there are 5 or 6 or 9 divisions of the Supreme Court, of the High Court here. It must be a general dispensation which is accorded by the Director of Public Prosecutions.
So Judge Ratha approached the JP Mlambo, and JP Mlambo said, "Not my monkey and not my circus. Definitely cannot comment on this. All on my own. This needs and then dun-dunnies of the dun-dunnies." And so Judge Ratha was left on his own. I mean, if the JP says nothing we can do, and we already know that has been the basic response of the JP, except when it comes to when are you finishing this case. He seems to have a lot of opinions on that, but not exactly on anything with regards to the merits of the case. For example, Judge Ratha's unprofessionalism in court that has been raised several times. The Sowetan called the courtroom a mockery of justice. Again, no comment on JP Mlambo on that. But then, this is a pattern with the JP. So I wasn't expecting much else after he said he consulted with the JP. So obviously the JP just halted and abruptly halted that whole idea about Justice Cameron, and of course Judge Ratha agrees with the JP. How can you disagree with the JP? But you know what? Let's keep going. One more thing is that, so now that the JP has put his foot down and not getting involved, and easy, says the JP, Judge Ratha is left on his own because he knows that Mnisi said, when we come back and you don't have a solution to my client's problem of being in solitary confinement, we will not proceed with this case because I need to pause to go and do X, Y, Z for my client so that I find representation for him and I find somebody else to take on the case and. So this is where we are, but let's continue on. Because in true Judge Ratha style, he's giving us a reading. Or should I say, he presents Mnisi with a case that he must follow of somebody whose rights were infringed. Last year, the verdict was made, and this was an inmate, an incarcerated person who wanted access to a laptop. Wait, that's Thabo Bester. But guess what? Thabo Bester's case is not yet concluded, which means this will also apply yet again to Thabo Bester. What a disaster. Let's listen on and find out what goes down.
So, concerning Mr. Mnisi's client, I did a bit of research. And I came across this case. The Minister of Justice, Correctional Services and others versus Ntuli and Judicial Inspectorate for Correctional Services as amicus. I'll give you a copy of this. This case was finalized on the 13th of September 2023 by my brother, Anta Halter. He was sitting with four other judges. And this case, I think it's the most comprehensive decision in South Africa concerning the Bill of Rights as it pertains or affects so-called prisoners or persons who are detained. If you read this case, you'll be able to find your way how you must approach the question of your client. Okay. Hello. It pertains only to that one. It pertains only to a so-called accused person or prisoner who wanted to exercise his rights to study, and he wanted to be accorded the right to have a computer, which he must utilize for his studies. But it traverses the Bill of Rights pertinently as it pertains to persons like your client. The only way you can visit that exigency is to bring an application to court, as suggested by Mr. Baloyi, which will have to define your client's rights pertaining to his incarceration, confinement, study, or exercise, visitations by friends, accused persons, or parents, etc., etc. So your only option, because when I read that decision, apparently it accords with what Mr. Nxumalo was telling Baloyi and yourself about the fact that apparently your client is alleged to be, I don't know, a security risk, whatever they mean by that. So you have to bring an application. There is no other way you can do it, because the Director of Correctional Services is alleged to be, I don't know, a security risk, whatever they mean by that. So you have to bring an application. There is no other way you can do it, because the Director of Correctional Services is the one who frames these regulations which control the incarceration of persons or prisoners, either awaiting or trial or those who are already sentenced. Okay. That's all I can tell you.
As it pleases the court, my lord, I'm indebted to the court, and thank you very much.
Okay, thanks.
For someone who listens in court, Judge Ratha surely does not listen in court. I mean, Mnisi only managed to get out a thank you so much. I am indebted to the court. Clearly there's a comma there, not a full stop, comma, as in he's going to say more. But the court immediately says, okay. No, Judge Ratha, you are not getting off the hook that fast. It does not end there with the reading of the case of Ntuli last year, which was concluded. No. You can hear the sheer disappointment in Mnisi's voice. But, attorneys, advocates, lawyers, they are creatures of instructions, and he must continue with the instructions from his client. I have to say, kudos to him for not throwing in the towel. Mnisi proceeds to restate again why this is not going to work. This is not going to work. These are the instructions from my client. And you know what? Let the interpreter interpret this as well. I don't want my client to think I'm the one saying this. So to me, that was an indication of Mnisi is having a hard time. Accused number 3 is giving him a hard time. Accused number 3 is giving him instructions and saying, hey, those are my instructions. Why aren't you following my instructions? So advocates cannot ignore the instructions of their clients. So he is caught between a rock and a hard place because 1, he definitely understands the plight of his clients. 2, he wants to work with his client and help him find a solution to this. And the court has just said, just do an application. Okay, just go ahead, do an application. You're on your own on this one. And Mnisi says, yeah, there's legal aid issues. I'm not going to be able to do this. I've told the court before. And he goes on and on and on. This for me was a devastating blow. Absolutely devastating blow. You know, when you expect better, I don't know. I guess it's time to accept that this is it. This is what this case is. I really did have hopes. I did have hopes for accused number 3. Nobody deserves to be in solitary confinement. Mnisi even says, I bet you in Guatemala, the conditions there are way better than they are here in South Africa with this solitary confinement thing. And what is so difficult, Justice Cameron, to stop with the reports? Did you hear how Judge Ratha says, yes, Justice Cameron sent another report to the JP Mlambo? I told you guys before in a previous video that Justice Cameron is just all about the reports. All about the reports, absolutely no action, a total waste of time. But look where we are now. Look where we are now. We can't have Justice Cameron come listen or do anything or force correctional services to come to court to talk. No. We just got to listen to the case of Untuli, which is what the judge has based his ruling on today. And an application is what he sticks his head out for. So let's continue on, and then I will be back with the rest of my commentary.
I'm not so sure whether I need to get a directive from Mr. Mnisi.
Yeah, you'll tell him what the law says and what that judgment pertinently says. That's the only judgment in South Africa.
Yes.
Concerning a Bill of Rights, concerning what your client complains about, amongst other things. Okay.
Yes. I'm not certain whether I can also request that what the court has just alluded to be interpreted to him as well.
Okay, fine. Mr. Interpreter, are you listening?
Yes, Monat.
Yeah,
But
fine.
it was a bit long.
Yeah, okay. No, the salient parts of it.
As the court places.
May I approach?
Yes.
As it please the court. My Lord, unfortunately, Mr. Mncube instructs me that it has come to a point where he can no longer take it because he has been in that situation that I explained before the research for 4 years.
Yeah, quite.
And now that it is indicated to him that unfortunately there is nothing that can be done in the meantime to assist him, and the only way through which he can be assisted is for him to bring a substantive application before another court to challenge his situation.
Yes.
He therefore requests, my Lord, that this trial should then stop.
Stop.
Yes, it is his request. Those are my instructions. That is what he's instructing me.
I know there's a political party which wanted to stop.
Maybe the word stop. It's another way, but then that the continuation with this trial be suspended in the circumstances, my Lord, to afford him the opportunity to contact his family, which he does not know how he's going to do it, to try and find out on his behalf if there's an attorney and an advocate who would be willing to bring that application for him. because he is saying further, he will not be in a position to start to drive or to prosecute that application when he's also concentrating in this case. And most unfortunately as well, my lord, I am also not in a position to assist in that application when I'm also supposed to be concentrating on this case. I can't be expected in the afternoon to go and assist in the drafting of papers, also prepare for the following day to come cross-examine and listen to, to analyze testimonies of witnesses and cross-examine them in this case. It's that will further perpetuate the injustices that he is complaining about, because then I will have to share my concentration. Fortunately, I would not be able to confront two fronts from different angles. To confront two fronts at a go. That I will not be able to do.
So you're saying this trial must be terminated because you don't want to, you have used the word stop.
No,
so
my
you're
lord,
saying
I
it
think
must
the
be
court
terminated. What are you saying?
No, my lord.
What are you saying?
As I said, probably the word stop
So
came out in a rather unsavory way. He's basically requesting that he be afforded the opportunity to try and get an attorney and an advocate through his family that is going to assist him. But the unfortunate part is he will not be in a position to do that when he's also attending this court. So that means for him to be able to fight the battle, which is such a mammoth battle that he's supposed to fight, is for this trial to be suspended for a
for how
while.
long? Suspended for how long? Let me tell you, I've never ever heard of a trial which is suspended on those bases.
Let me then explain the following. Probably the court is also for the first time that is meeting a situation where a person is held in solitary confinement for 4 years, which is the reason why the court has not yet heard of such a situation.
Wait. I just went out of my way. No judge will do what I did.
Yes.
Research the law and come with an SEA decision to you. And I can tell you, this matter, this has been taken on appeal. Are you aware of that? That Mncube'S case.
I know Advocate Msholola did refer to the case.
Yeah, but
this case at some point.
It's been taken on appeal to the Constitutional Court. So the Constitutional Court, I don't know when they are going to handle that matter, because whatever they do, that case is the most relevant. Because
it's the binding authority at the moment.
That's it, yeah.
The circumstances, my lord, of this case, as I heard the court trying to elucidate on them, are different in that somebody who is not held in a solitary confinement is requesting for amenities to enable him to study, like laptop and all those other studying gadgets. But here, we are talking of a person who is mentally drained, a person that has been in solitary confinement, who has got no access to television, who has got no access to a radio, who has got access to virtually nothing, no newspaper, no nothing. And he is supposed, or he is expected to formulate a defense in a case of such a magnitude. That is totally unfair. That is totally unfair. So these two cases are totally distinguishable.
Are you saying just to draft a founding affidavit challenging the conditions under which he's been incarcerated, you need this trial to stop?
My lord, I am only conveying what he is
No,
requesting.
you're fine.
Because maybe he personally intends, because even his funding in respect of this case is done by legal aid.
Yeah, you can apply for legal aid again, no problem.
I'm not even so sure whether, my lord, that they will be able to do that, but I will try. I will try. I'll try to communicate with them during lunchtime. If circumstances permit, I'll bring the answer after lunchtime, my lord.
No, I can tell you now.
Yes.
The interests of justice don't allow that request. I can't. This case, There are 4 or 5 accused persons before me. There are the complainants, there are the witnesses, even myself. I can't be sitting in this case until I die.
Maybe, my lord,
So, there are-
my lord, in those circumstances, because this is a situation sui generis, probably it will be a justification.
To do
Now I'm thinking out of the box. It will be a justification to apply for a separation of trial then, to afford him the opportunity to go and attend whatever that he wants to attend. Meanwhile, the trial, so that to prejudice the other accused with the
No, no.
continuation
If
of
you
the
say you
trial.
want the separation of trial,
Yes.
what happens to the evidence which has been led? I've never heard.
It will
I've
still
not-
be
just listen to
relevant,
me.
my lord. It will
I've
still
never
be
heard of a
relevant.
separation of trial at this late stage. Never.
But does the court really understand, my lord,
I do.
to stay in solitary confinement
I do. That's why.
for 4 years?
That's
What
why-
does it do to the mind of a person?
That's why I became concerned.
Yes.
I engaged the JP. I engaged the Directorate of Inspections. And I even went to the law. And this is not a difficult application, please. It concerns a Bill of Rights. That's all it concerns.
My lord, it is so. It might not be a difficult application to a person who knows the law.
Yeah.
But to a person like him,
You know the law.
who
You know
probably,
the law.
but I've just indicated, my lord, that I'm not prepared even with an inch to concentrate in this trial, at the same time be involved in a separate substantive application, which has got to do with his
so what
housing.
is your
That I'm not
application?
prepared
Okay,
to do.
fine. What
And
is your-
if I'm not prepared to do it, my lord, then he then has got to do it himself. That is where then that notion of to draft an affidavit for in terms of a person who knows the law might not be a tedious thing, but to a person who knows the law, such as him, it's going to be a very tedious
Yeah, he's
thing.
going to instruct a lawyer, obviously. Okay. I'm sorry, I can't accede to any of those requests. Separation of
take
trials,
instructions, my lord.
stop the trial. I can't do that.
Let me take instructions, my
Yeah,
lord.
fine.
But before I do that, I also wish to bring it to the attention of the court, my lord, that it also hinders me because instructions that are coming from him, at some stage, they don't make sense. You can see that this is a psychologically impaired instruction. They just don't make a sense, my lord. It also hinders me a lot, and I'm expected to bring sense to the court. How do I bring sense to the court in circumstances where I'm getting instructions that are psychologically hindered by virtue of the fact that a person has been in custody in solitary confinement for 4 years? I don't think even at Guatemala prison that is still the position, my lord. Thank you. Let me take instructions.
Yeah, okay, fine.
That was absolutely heartbreaking. But I think what is even more heartbreaking is listening to Mnisi try to explain the conditions. I think that we didn't really quite get a grasp of what solitary confinement means. Yes, no access to TV, no access to the internet, no access to others. Being in solitary confinement for 23 hours, and then that hour when you do get out, you just see the sky. Take a moment to close your eyes and think of that moment. There's a time when someone said it was like when we were in lockdown. We were in lockdown with our families. Now, think of lockdown and then remove your family members. And then think of yourself, just yourself. We all went through that lockdown and it was not a great experience. It was difficult. It was difficult. Now think about being in lockdown and then trying to prepare for your trial where you're being accused of a crime where you are not guilty of. Okay? And then think of preparing for that trial with no resources. Tabo Bester tried to explain this as well, where he's handwriting everything. He's handwriting everything. He can't watch anything that is being said about him so that he can respond to it or use it in his case. No, he cannot. He has access to absolutely nothing. This is heartbreaking. Mnisi therefore goes ahead, I think goes beyond client confidentiality privileges and says he doesn't even make sense in his instructions. This is the impact of this solitary confinement. And there's nothing I can do to assist him because his instructions are not making sense anymore. That absolutely broke my heart. I don't think any human deserves that, especially since they have not yet been found guilty of this crime. Let me know your thoughts down below in the comment section. And again, Mnisi Wemvula. If you're a member of the channel, please go ahead and drop Mnisi Wemvula emoji because wow, he doesn't stop. He goes back to get instructions and still continues, giving Judge Ratha a run for his money. This is devastating. This is the Mzansi we live in. And take away the fact that it's accused number 3. This could be you. This could be a family member. This could be a coworker that is being accused of a crime they did not commit, or they are saying they didn't do it. And then they're suddenly thrown in solitary confinement, where no other of the other 5 accused are also in solitary confinement. Not even Mr. Sifisukuhle Ntuli, who took out 6 lives. He's not in solitary confinement. Why only accused number 3? This is absolutely devastating. Let's listen to the final part, and I'll be back with the rest of my commentary.
Yes, sir.
As it please the court, my lord. My instructions are that he has been in custody in solitary confinement since 2019. People have come in and went out. People who have reoffended while in prison, they've stepped police and everything. They've stepped other inmates, they went in and went out. Now, apparently he is told that one of the reasons why he should be kept in solitary confinement is because of this case. Now, his question is, some of his colleagues that are also attending, with in this case, that is co-accused, are not in solitary confinement. So why should it be him that is in solitary confinement because of this case, when other accused that are also involved in this case are not in solitary confinement? He still insists that may the court please have passion, mercy, and compassion to allow him an opportunity to go and think of a situation or of an idea on how best could he tackle this situation. Because he says, my lord, he cannot even concentrate here at court, because each time he comes here, he's got to think about his conditions where he is housed, as to the reason why is this injustice actually being perpetrated. When he leaves here, he hardly has got time to think about what has been happening here at court for that day, because he spends most of his time in solitary confinement thinking about his agonies. He's basically agonizing about his stay there.
No, fine, I hear that. He must bring an urgent application. He's got the right to do that.
In the meantime, what should then be happening? Because I've got no instructions
meantime, there's nothing-
to cross-examine this witness.
No. In the meantime, there's nothing this court can do, because the Commissioner of Correctional Services has made an order. Am I correct, Mr. Balwe?
Yes, indeed. And
Yeah, I mean-
we try to the best of our
Yeah.
ability to mediate, but it's about
That's
separation
it.
of
Yeah. So
powers.
that order must be set aside.
Yes, they exercise powers in terms of the Correctional Services Act.
That's it, yeah.
And,
There's nothing this court can
there's
do.
much we can do.
Okay, can we just start with
This
this
is the
matter?
message, my lord. The court cannot compel me to start, my lord. I'm a creature of instructions. If I don't have instructions to start, I can't start. But this is
So,
what he's saying.
Mr.
Yes.
Are you saying if your client says you mustn't start, you're not going to start?
No, but my lord, I
No, I'm
need
just
to have
asking.
instructions. I cannot act against his instructions. And this is what he's saying. Ikhoto uma ifuna ukuqhubeka ngenkani yayo, ingaqhubeka. Kodwa mina yazi ukuthi ngihlukumezekile engqondweni. Ngicabanga indlela engihlukumezeke ngayo. Those are my
Yeah, fine.
instructions.
I sympathize, and I'm very human about this situation. That's why I'm saying they can bring an urgent application against the Correctional Services, the Minister, the Director, and they can even cite the Department of Justice also.
May I then request, my lord, that we have an adjournment I consult, actually I talk to legal aid and find out if there's something that he can do in respect of this, because basically he is their client. Thank you.
Yes, Mr. Baloyi.
It's 7 minutes to 11. Maybe we can then take the short adjournment, the normal short adjournment until about 11:30.
Okay, I'll come back at 11:30.
Baloyi. He's just like, we've got 7 minutes. Let's just go on the short break. They are still on the adjournment at the time of the ending of this recording, which has been, let me do a time check. It's been a while. So kudos to Mnisi. 15 minutes is not enough to cut it. Mnisi needs to get a hold of legal aid. Mnisi needs to find out what legal aid is going to do. Are they going to cover all this? Because Baloyi is not offering any assistance. The IO over there is like, no, keep him over there in solitary confinement. Judge Ratha is saying, listen, we are continuing with this case. Nothing I can do. This court sympathizes. I am also human, but I'm doing nothing about this. Okay, do an urgent application somewhere else. I don't know how he's going to do an urgent application from solitary confinement with access to no one, no internet, nothing. This was a difficult video to edit. This is not where I thought we were going to start after recess. Everybody's back with a brand new hairstyle. But this is devastating. Nothing has changed in that courtroom. Nothing at all. This is the end of part 1. I'm going to go ahead and upload the second video as well. So make sure you like, comment, and subscribe. And we're going to part 2, where there's more bad news. It gets worse. It can only get worse. And I have 3 words for you. Baloyi, Baloyi, Baloyi.